Now, welcome everyone. My name is Shui Wang. I'm class of 96 and a member of the Williams Asian and Asian American Alumni Network Steering Committee. Thank you all for joining us tonight from wherever you are for this presentation. As you know, this year we're celebrating the 30th anniversary of WAAAN and also the inaugural year of Asian American Studies on campus. After decades of hard work and advocacy by students and alums together, we're excited that there are this June, for the first time, seniors graduating with a concentration in Asian American Studies. WAAAN has lots of events planned to mark these milestones, including what promises to be a fascinating presentation today about how Asian Americans and Pacific Islanders have shaped the U.S. legal system. It's my great pleasure to introduce today's speaker, Bob Kim, class of 1992. Bob is a leading expert in education law and policy in the United States. Currently, he is the executive director of Education Law Center, a legal advocacy organization dedicated exclusively to advancing and protecting public education and the rights of public school students nationwide. Previously, among many other distinguished positions, Bob served as a member of the Biden-Harris Presidential Transition Team, as Deputy Assistant Secretary in the Department of Education Office for Civil Rights during the Obama administration, as a senior policy analyst at the National Education Association, and as a staff attorney at the American Civil Liberties Union of Northern California. He has written extensively on legal and policy issues impacting public education, including this book, Elevating Equity and Justice, 10 Supreme Court Cases Every Teacher Should Know. It's no wonder why Bob was honored by the college as a 2023 recipient of Williams College's Bicentennial Medal for Distinguished Achievement. We're extremely lucky to have Bob here tonight to share with us some Supreme Court cases and the stories behind them, so we can better understand how Asian Americans and Pacific Islanders have shaped the important legal rights we enjoy today. So the format for today's presentation is that Bob will speak until about 7:40, 7:45 Eastern Time, and at that point, we'll open the floor for questions. Feel free to raise your hand, come on camera, ask your question. You can also type your question in the chat and I'll read it out. So without further ado, I'm going to turn things over to Bob.
Thank you, Shui, and thank you, Juan and Williams, for having me. It's so great to be in a room full of youths. It's been so long since I've had the pleasure of saying that. And you know, it's so funny because I spoke to a current Williams student a few weeks ago, and she introduced me to a friend of hers, and she was like, "This is Bob Kim. He went to Williams in the 20th century." And it immediately made me feel like I was like from the Han Dynasty or something like that. So it was ridiculous. But yes, I did go to Williams in the 20th century. I was an Asian studies major there. So it's so interesting as we talk about Asian American issues tonight. I didn't actually learn a lot of Asian American issues at Williams, but I'm so thrilled to learn that Asian American studies is now a focal point or an option for Williams students currently. My field, as Shui mentioned, is in civil rights and education. I'm involved in litigation advocacy right now that deals with things like K-12 school finance issues, school desegregation. You know, we're involved in a couple state cases involving deseg, if you can believe it, 70 years after Brown versus Board of Education. I'm also involved in issues around trying to counter attacks on public education involving censorship, vouchers, and school privatization movement. Religious charter schools, which is an issue coming up, and also other equity issues in education involving race and gender, Title IX issues, and disability-related discrimination. So all of that is my background. It's sort of a disclaimer to say that I'm not, counter to the topic tonight, I'm not a legal historian, nor am I a critical race theory expert, although I'm going to mention some critical race theory tonight. And I'm not an Asian American studies scholar per se, but what I am is a fan of court cases. I use them in my work, and I really think they're a great teaching tool. So I'd like to share some of that enthusiasm with you tonight. And this talk, by the way, is adapted from a talk that I did a few years ago for the Smithsonian Asian Pacific American Center. And so without further ado, the next slide, please. My goals tonight are really simple. It's to talk about some cases involving the AANHPI community. That's a mouthful. Sometimes I'll just shorthand and say AAPIs. And I think the cases that I'm going to talk about really debunk some stereotypes about our community. You know, this idea that we're a model minority, which you've all heard about, that there's that notion as a model minority that we should not have legal issues happen to us, you know, that we don't have complex lives, that we are all successful. That's belied by some of the cases that we'll talk about. Another myth is that, or stereotype is that we're all obedient and quiet, and certainly that we don't assert our rights. And in fact, historically, Asian American and Pacific Islanders have been quite strong and resilient in and defiant in asserting their rights in the courthouses. And then finally, that we're all monolithic somehow, that we're not diverse within the pan-AAPI community. The cases tonight range from Ivy League students to blue-collar day laborers to immigrants to Pacific Islanders, people from all over the world and of varying socioeconomic statuses. So certainly, even in this small snapshot of cases, we know that we're not a monolithic community. And then also in the presentation, hopefully we can connect some of these cases or in our Q&A to current events and what's going on right now in the world, and engage in some critical inquiry about the US legal system. You can't talk about US Supreme Court cases or other legal cases involving AAPIs without wondering how such esteemed jurists, including the United States Supreme Court, can act so cruelly and so despicably in some cases when they involve AAPIs. And so I think that naturally leads to critical inquiry about the system overall and how effective it is in asserting and advancing civil rights in the United States. So those are some goals. Next slide, please. Why should we care about these cases? I have many reasons why we should care about AAPI cases. I think for purposes of this crowd, I will just skip right to number 7. We are products of liberal arts education, and I think that court cases and law should be part of every student's liberal arts education. They're not something that should only be learned in law school, but in fact, everyone, and I argue in one of my books that even young students, K-12 students, should know the rudiments of law and rights and civil liberties, because really the world and the United States is a nation of laws and everything's governed by laws. And I believe that it's, they say knowledge is power. Well, not even more powerful is knowledge about how power is baked in and codified into structural frameworks that govern our society. So I really think that these cases are should be part of everyone's liberal arts education. And next slide, please. And some of the key questions I think that we'll ask tonight is that are raised by these cases is who is an American? Concepts of nationality, citizenship, and status as an American have been really defined and established in part from legal cases involving AAPIs. So we'll talk about that. Next slide. And just in defining what American is, I know that many of the most famous cases involving AAPIs really come from immigration cases. And I think we want to ask, why is that? Why is AAPI identity so intertwined with this question of entry into the United States or exclusion from the United States, or really the idea of belonging to America? And there's so many questions from that. Like, is it that as a disenfranchised minority, historically, did we lack power or even assets to engage in other types of litigation, like, for example, corporate law or property law, for example? Why was it that so many of the cases involved situations when we were being denied entry into the country or being kicked out of the country? So I think that's just an interesting question to ponder around our history and involvement in the U.S. legal system. Next question, or next slide. The next question is, what does equality mean? In my line of work, civil rights advocacy, there are so many concepts around equality that we focus on. There's issues of access to things that the government should be providing, access to schools, to a quality education, for example, access to the country and the benefits of being an American. But I think also there's notions of equality, meaning, for example, equal treatment. How is the government treating us and applying laws? Are they applying laws equally to us? And finally, as we kind of think about the Harvard case, the affirmative action case, there's really a notion of how should the government go about in creating equality? Are we supposed to remove all consider of race altogether and be colorblind as we try to achieve equality? Or should the government consider race and be somewhat race conscious as we try to create equality? So the idea of race consciousness, I think, is an important concept to consider as we struggle with this question of what does equality mean. Next slide. I show you a picture here to give us a prelude of the struggles of AAPIs in achieving equality. This is a 1876 depiction of a gun, and you might not be able to see it, but on the handle of the gun, there's this there are these words, inscription, that the Chinese must go. And I think on top of the gun, there's a policeman kicking a Chinese person. And I just depict this to show that equality has been tough for our community historically, and we can see that borne out in the cases that we're going to talk about. Next slide. And then the final question I think that's worth raising is, what is race? Race in and of itself. And how did AAPIs help define race in the United States? The Asian American critical race scholar Neil Tanda described in his article a critique of our colorblind Constitution. He described how in the middle 17th century in the United States, race as we know it today was not clearly defined. And in fact, race was only legally codified in 1705 in Virginia by the Virginia State Assembly in order to distinguish Blacks and quote unquote mulattoes from European indentured servants. And so we saw how race was developed in the US as a construct to manage and restrict access to rights and liberty and humanity, really, as applied to African Americans. And so we also see that in the AAPI cases, how race is being used as a way to define and limit rights as applied to AAPIs. Next slide. And then next slide after that. And so the first case that I want to talk about, getting right into it today, is involving a gentleman by the name of Takao Ozawa. And this case, it's also about citizenship and what being American is, but I use the case to focus on how race is defined in the US and how Asian Americans are used as fodder for that question of defining race. So the next slide. So Mr. Ozawa was a graduate of Berkeley High School and UC Berkeley. He was actually born in Japan, and he applied in 1914 to be a citizen of the United States. The Supreme Court ended up denying his citizenship based on the fact that immigrants could not become citizens unless they were quote unquote free white persons, i.e. Caucasian, and that Takao was clearly of a race which is not Caucasian. And the US Supreme Court in this case based its ruling on some naturalization laws from the 18th and 19th centuries that denied the privilege of naturalization to aliens unless they came from, or unless they fell within the description of, quote, free white persons. And, an interesting thing about this case is how much the Supreme Court at the time struggled with the issue of color, race and color, and ended up gravitating towards something that was more akin to geography in order to define race and define whiteness. And I'll just quote a little bit of the case. The Supreme Court was saying, well, clearly, like sort of mere color of skin is impracticable as that differs greatly among persons of the same race, even among Anglo-Saxons, ranging from fair blonde to swarthy brunette, the latter being darker than many lighter-hued persons of the brown or yellow races. And so therefore, it's easier, the Supreme Court said, to basically say that white persons should be synonymous with a person of the Caucasian race. And clearly, Mr. Ozawa is not Caucasian. And so therefore, you see race being used this way through Mr. Ozawa to say that race means not, white means not Japanese American, white equals Caucasian. Next slide. And then, so got it. So we have the Ozawa case establishing that. And then we move to the case of Bhagat Singh Thind. Next slide. Now, Mr. Thind was a South Asian American who fought as a soldier for the United States in World War II. He applied for and was initially granted and then later denied U.S. citizenship. So remember, from the Ozawa case, we had white equals Caucasian. Well, here, what was complicating to the Supreme Court was the fact that Caucasian includes Hindus, and not only Hindus, but some people of Polynesian descent, that is Maori, Tahitians, Samoans, Hawaiians, and others. And I'm still quoting here, the Hamites of Africa, upon the ground of the Caucasic cast of their features, though in color they range from brown to black. And so the court went on to say, well, of course, the average well-informed white American would be surprised to learn that the race to which he belongs is made up of such heterogeneous elements. And so it may be true that the blonde Scandinavian and the brown Hindu have a common ancestry, but in the end, the physical group characteristics of Hindus are readily distinguishable from those that we would recognize as white. So the court upheld the denial of citizenship of Thind, even though, according to the prevailing science, he was racially white, but they limited whiteness to apply to Thind and limited it so that only those that were exclusively from the British Isles and Northwestern Europe were going to be considered white moving forward. So we had a bait and switch from the Ozawa case, further narrowing the definition of what it means to be Caucasian and white, defining race by what it's not. AAPIs were used to define whiteness, but they were simultaneously excluded from whiteness and the privilege conferred by whiteness. So we have Ozawa to Thind, and then the next case. On the question of who is American, we have to go a little further back in time to the famous Chinese exclusion case. And this was way back in 1889. Little historical primer for those of you that don't know in about 20 seconds. The Chinese Exclusion Act was passed in 1882. It was the first law implemented in the United States to prevent all members of a specific ethnic or national group from immigrating to the United States. Under the act, Chinese laborers already in the U.S. could return to the U.S. if they went overseas. But then the Congress passed the Scott Act in 1888, which abolished one of the exempt statuses with returning laborers. And so what that did is it stranded about 20,000 Chinese Americans that were holding what were called certificates of return, excluded them and kept them outside of the United States. So this fellow, Che Chan-ping, was a Chinese citizen who had been living and working in the U.S. from as early as 1875. He left to visit China, and then he was barred re-entry to the U.S. due to the passage of the Scott Act. And the Supreme Court here ruled in favor of the government. It said that Chinese laborers are not citizens of the United States, they are aliens. And this case really contributed to the notion that the federal government has plenary power to control immigration policies. It's the feds, not the states in the US, that have this power. And that principle has governed thousands of immigration cases since, involving entry to the country, deportation, asylum, and so forth. We see here that AAPIs were the vehicle for developing modern immigration law. And we really established the contours of federal power, the rules around entry into this country, the concepts of alien versus citizen, and who gets the privileged status of being an American. So a very important case that really holds power even today. Next case. And then we go to the case of a Cambodian American named Moni Preep. And this is a modern application of immigration law, very recent. Moni was a legal permanent resident born to Cambodian parents in a refugee camp. He had lived lawfully in the US since 1981, but he was convicted of 2 drug offenses that qualified him for mandatory immigration detention prior to his removal from the US under federal law. And so even though he was released from criminal custody in 2006, immigration officials didn't detain him or think to detain him until years later in 2013. So he challenged his federal mandatory immigration detention. He challenged the federal mandatory immigration detention statute that permitted the jailing of individuals in removal proceedings without a hearing on whether the individual poses a danger or flight risk. And by a 5-4 vote, the Supreme Court held in 2019 that the government can detain immigrants subject to removal without any hearing on flight risk or dangerousness, even when they're taken into custody long after they've completed a criminal sentence and demonstrated that they are law-abiding. This case follows a 2003 case also involving an Asian American named Kim in the Denmore case. And that case also upheld mandatory detention of immigrants subject to removal proceedings. And so we see here AAPI litigants challenging their detention. We see that there's expanding power of the federal government regarding detention in the immigration context, which is very different from cases involving US citizens, because as you know, US citizens, we have the 4th Amendment, which protects against involuntary search and seizure or confinement without probable cause. We also have normal rights of due process, which guarantees the right of hearing before punishment. And that's very different in the immigration context. And unfortunately, AAPIs have been involved in the major cases establishing and increasing the government's power to do these things without ordinary due process or other protections. Next case. On the positive side, we have Wong Kim Ark. This is an 1898 case. Next slide. This case establishes that AAPIs were involved in the major doctrine of citizenship to the United States by birth. If you're born in the United States, you are a citizen of the United States, regardless of your prior generations and immigration status or history. And so we have Wong Kim Ark, who alleged that he was a citizen of the United States, after all, being born in San Francisco, in 1873. And the government alleged that, no, he's not a citizen. He's been at all times, by reason of his race, language, color, and dress, a Chinese person, i.e. not an American. The court ruled here in a very groundbreaking case that the plaintiff was a US citizen by virtue of the 14th Amendment of the Constitution, which states that all persons born or naturalized in the US are citizens of the US and the states wherein they reside. And so this case really greatly added to the historical diversity of the United States, even though immigration laws later have become more restricting in admitting foreigners to the US. Think about how many generations of students and children, Asian Americans in this country, have become U.S. citizens by virtue of the Wong Kim Ark case. So thank you, Wong Kim Ark. And yet, next case, we have the situation involving John Fidesimanu. Next slide. John was born in American Samoa. He was a U.S. national living in the state of Utah, and he and two other plaintiffs argued that, yeah, like under Wong Kim Ark, they're U.S. citizens. You know, they were born in American Samoa, U.S. territory, and that they should become U.S. citizens under Wong Kim Ark. The Supreme Court did not agree with that ultimately, or you can see the pathway here from the lower district courts. But the problem here was that there were a bunch of cases from the US Supreme Court from the early 20th century called the insular cases. And those addressed whether the Constitution applies by its own force to in any territory of the US that is not a US state. And those cases really held that there's an implied denial of the right of inhabitants of US territories to citizenship unless Congress further acted to bestow that right of citizenship to folks in US territories. And so unfortunately, although Fidesimanu won in the federal district court, he lost in the Court of Appeals, and then the Supreme Court denied to hear the case recently. And so basically, Wong Kim Ark case does not apply to folks from US territories. There's a bunch going on in this case that we don't have time to get into, but as you know, there's a distinction now between incorporated territories or former territories like Alaska and Hawaii. Then there's many unincorporated territories, including Puerto Rico, Guam, Philippines, Northern Mariana Islands, US Virgin Islands, American Samoa. And so there's different rights bestowed to folks depending on your territorial status. And of course, the backdrop to all of this is we can't ignore the US history of annexation and colonialization of those territories. And so, you know, i.e. American imperialism. So you have this double whammy of colonialization of territories and the subsequent unequal status and treatment of people from those living in those territories. And so we see here, unfortunately, Pacific Islanders in litigation defining the limitations of citizenship by birthright today, even though they also define citizenship by birthright in the Wong Kim Ark case. Next slide. And so now we move on to the Yik Wo case, and on to the question of what does equality mean in the United States? And racial inequality in particular. This is a very unflattering picture of Chinese laundrymen in San Francisco in the 1800s. And it's a depiction that forwards us to the case of Yik Wo. Next slide. Yik Wo is a laundry facility owner. It was a laundry facility owned by a gentleman, Lee Wick, who immigrated to California in 1861. After 22 years of managing a laundry facility in San Francisco, the city said that he could not continue to run that facility in a wooden building without a permit. And that was prescribed by a local ordinance that you needed to have a permit if you had a laundromat in a wooden building. So Lewick continued to operate his laundry. Nevertheless, he was convicted and fined under the ordinance. He then filed a writ of habeas corpus after he was imprisoned for refusing to pay the fine. And here we get into the issue of race-neutral laws. You know, the case here involved the requirement to have a permit for doing business in a wooden building. I mean, that's not discriminatory, right? It's race-neutral, simple enough. You know, why would you have such a law or ordinance? I mean, I can think of many involving, you know, not wanting to create a fire risk in the city, maybe other safety concerns. You know, you need a permit. That has nothing to do with race. But the context here was at that time in San Francisco, about 95% of the city's 320 laundries were operated in wooden buildings, and about 2/3 of those laundries were owned by Chinese people. And the catch here, although most of the city's wooden building laundry owners applied for a permit, only one permit was granted of the 200 applications from any Chinese owner, while virtually all 9 non-Chinese applicants were granted a permit. So you can see the plight here of Lee Wick. And the court found that the administration of that ordinance in question was discriminatory. So even though these Chinese laundry owners were usually not American citizens at the time, the court still ruled that they were entitled to equal protection under the 14th Amendment. So that's very important. Even though they were not citizens, they're still entitled to equal protection. The case is also huge, Yip Woe, because, really from the 1950s, the Supreme Court used Yip Woe to strike down many attempts by states and municipalities in the Deep South to limit the political rights of Black people. And so the case has been cited in well over 150 US Supreme Court cases since it was decided. The lesson here is that race-neutral laws or policies can have a discriminatory effect or be applied in a discriminatory manner against a particular group of people. And it was really this AAPI, Lee Wick, who established one of the most important civil rights principles in American history. It's not just how a law is written, it's how it's applied and enforced. Next slide. And yet, we arrive at one of the most infamous and horrible cases in US history, the Korematsu case. This is the Japanese internment case. You all have heard about this. I had the very great honor of meeting Mr. Korematsu before he passed away a few decades ago. And next slide. There you see a picture of his family, really just a gem of a human being and a real patriot and hero. And then the case is on the next slide. Here we have a long history. I'm not going to have time to go through all of this, but as you may know, about 10 weeks after the U.S. entered into World War II, FDR signed an executive order which authorized the armed forces to remove people of Japanese ancestry from what they designated as military areas and surrounding communities in the U.S. The order set in motion the mass transportation and relocation of more than 120,000 Japanese or Japanese Americans to sites that the government called charitably detention camps. And all of this happened and were occupied in about 14 weeks. Fred Korematsu was 23 years old at the time, was a Japanese American citizen who did not comply with the order to leave his home and his job. And so in 1942, the FBI arrested him for failure to report to a relocation center. Now, this went all the way up through the Supreme Court, and on December 18, 1944, the court held that the detention of this Japanese American citizen was a military necessity, not based on race. At the same time, the court also set up a strict scrutiny apparatus, which is very prominent now in equal protection law and court cases, which held that, to justify racial unequal treatment by the government, that racial unequal treatment is presumptively unlawful and is really subject to a very high bar to pass muster. So we have the irony here of AAPI case, infamous case, Korematsu, setting up the architecture of modern equal protection jurisprudence, which holds that race discrimination is really presumptively illegal and you can't do it. But that was in the context of interning and detaining Japanese American citizens just because they were Japanese. This case, by the way, was only overturned in another infamous case. You might have heard of one of the parties in the case, Donald Trump. In the case of Trump versus Hawaii, and again, that case was the so-called Muslim ban case. Do you remember that from 2017 and 2018? The government wanted to justify arbitrarily not placing entry restrictions on nationals of 8 predominantly Muslim countries or nations. And the Supreme Court upheld the broad restrictions placed by President Trump of keeping Muslims out of the United States. And, so it's sort of interesting that that was the case in which they relied on former AAPI precedents. Think back to the Che Chan-Ping case, think of the Korematsu case. They upheld Trump's right to bar access to Muslims, but then in a sidebar, they said, oh, and by the way, Korematsu has nothing to do with this case. That case was gravely wrong the day it was decided. It's been overruled in the court of history and has no place under the law, under our Constitution. So you get the overruling finally of one of the worst cases in US history, the Korematsu case, in the context of denying Muslims entry into the case as enacted by former President Trump. Okay, and then now I have 3 more quick cases and I'm just going to fly through them so that we can get to conversation. The next case involves Martha Lum, who's the daughter of Gong Lum. And I bring this case up primarily to remind us all that Asian Americans were part of school segregation in the United States. Next slide. Asian American, Martha Lum was a US citizen, and this case, as you know, predates Brown versus Board of Education by more than 30 years, or almost 30 years. A couple of decades prior to this case, the Plessy case had affirmed the doctrine of separate but equal way back in 1896. So pre-Brown, you get this case involving Martha Lum. She was a 9-year-old Chinese American girl. She was prohibited from attending Roseland Consolidated High School in Mississippi solely because she was of Chinese descent. And the court said that, yeah, we've upheld separation of white and blacks, and the same is true regarding separation of white and yellow pupils. We're not talking about eyes, we're talking about students here. So the court this case reinforces the notion that AAPIs were inferior or thought of as inferior. And so separate and equal or separate and unequal was okay back in the time. And it's really reminds us, back to the principle Neil Gotanda wrote about, which is that racial classifications have been offered in the United States as a basis for legitimizing subordination. It's really where we talk, these cases, you hear a lot about yellow people. And I think yellowness comes a lot from the law, not just from common discourse. And it was how racial classifications and yellowness being used as a way to subordinate Asian American rights historically. Next case. The Lau case, I wrote about this in one of my books. Kenny Lau, or Ken Lau as he came to be known, was a litigant who really did solidify the rights of English language learners in the US to a meaningful education. He attended an all Chinese American school in San Francisco back in the 60s, I believe. And in San Francisco at the time, there were nearly 3,000 students who didn't speak English, Asian American students who didn't speak English at all. And most of them were not getting supplemental courses teaching them how to speak English. And then on top of that, California law said that all instruction in public schools had to be in English. So how was Kenny Lau going to be educated? And so this case, the Supreme Court ended up saying that that was unlawful and that English learners have a right to receive a meaningful education. The legacy here is that the case spurred what are known as Lau plans for English learner students nationwide. It established the requirement that English learners have to receive a meaningful opportunity to receive instruction that enables them to participate effectively in their school's education program, whether that's through bilingual education, whether that's through dual language programs. And on top of that, EL students' education can't just be about learning English. The government has to enable them to access the whole curriculum, not just learning English. And all of this is thanks to Kenny Lau and the Lau case. Next case. And then finally, we come to, and I'll conclude with the affirmative action case. You all know this case. Next slide. This is Students for Fair Admissions versus Harvard College. UNC was also a defendant in the case. So you have a private university, you have a public university being sued. The hook for the public university UNC was the Constitution, because public institutions are subject to the Constitution, and the hook for Harvard and all other private colleges is Title VI of the Civil Rights Act, which can cover private entities as well as public ones. So the lawsuit was filed by this group called Students for Fair Admissions, and it included more than a dozen Asian American students who applied to Harvard and were rejected. And these students contended in their lawsuit that Harvard systemically discriminated against Asian American applicants in violation of federal civil rights law, and it penalized their high achievement as a group while giving preferences to other racial and ethnic minorities. They alleged that Harvard's admission process amounted to an illegal quota system. And of course, you know what the Supreme Court did. It basically agreed with the plaintiffs. It held against Harvard and USC, and basically that dismantled the entire system of affirmative action in post-secondary colleges and universities nationwide. It was a violation according to the Supreme Court of Equal Protection in Title VI. And there's some interesting aspects about this case. You know, you'll see the dissent had some, Justice Jackson and Justice Sotomayor had some very, very insightful, long dissents that related to basically how ahistorical this opinion was. It just denied the entire history of the 14th Amendment, the Civil Rights era, and what we needed to do in this country to rectify past discrimination, and how many barriers there are for students of color to gain entry to selective colleges today. Some would argue that this case was the strategic marshaling of a claim of anti-Asian discrimination, not to remedy anti-Asian discrimination, but to discredit and stigmatize affirmative action. And I'll just conclude by saying, there was some evidence during the trial that there were application procedures that arguably sort of relied on negative stereotypes of Asian Americans. All of that, there was the lower courts held there wasn't proof of any kind of intentional discrimination in that way by Harvard or other elite colleges. But, there's a legitimate question, I would argue, as to whether there is unconscious or intentional bias in admissions processes as applied to Asian Americans. But that's separate really from whether it's unlawful to consider students' race at all to create a diverse student body. So in my view, this was a horribly wrong opinion. I think we've seen it affect admissions procedures and applications. Many of you probably are painfully aware of the changes in the admissions procedures. I've noted Williams has stopped saying what students of what race have been accepted or admitted to Williams. So it really has changed the landscape overall. And I think we could talk about the continuing repercussions in the Q&A. And so with that, I will shut up and let you all talk. Oh, but just to say that there are broad takeaways and questions which I'm not going to go through. You can read them here from these cases. I think that they really show the influence of AAPIs in litigation, and they raise a bunch of questions about how courts treat us as a community and what these cases mean for today, what they mean for our continuing struggles as we move forward. And with that, I will now shut up.
Thank you so much, Bob. That was really fascinating. I think these are really important cases, and I'm sure everyone learned a lot from your summaries. I don't know if I don't see any questions in the chat. I'm going to kick us off, but please do either raise your hand, come off camera, just ask your question directly, or put it in the chat. Oh, Austin has a question. Maybe we'll start with Austin.
Great. Well, of course, I'm an older generation person. I was one of the first Asian Americans at Williams College, and maybe 3 or 4 others. But talking about all this, unfortunately, politics is an important issue, and we the Asian Americans have not been overly involved in politics, but it's vitally important, as you touched upon, because unfortunately we have such a divide in our country. And Trump and the MAGA Republicans really are, without holding punches, they are basically racist. But let's even forgetting that, they advocate for policies which we generally uphold, that's dear to us, like you pointed out, how important education is and public school education. And places like Williams, value that too. So we value great education, but we also value access to for public schools and all that. So I'm kind of disturbed that it seems like the older generations of Asian Americans are not more, I hate to say, more liberal leaning or more democratic leaning. And I'm not sure what it is. Maybe some of it is that they think, well, we've made it and so can they, and why do they need a handout? And we as Democrats try to point out, we're not trying to give anybody a handout. We're just trying to just level the playing field and giving them a chance. So unfortunately, I have to say this, that politics now is so important, because I really worry about Trump and MAGA Republicans. And there are some good, there are a few legislators that are Asians that are very good, like Ted Lieu in California and others like that. And generally, I got to say that the ones that we do have are very good. Unlike some I don't know, I'm going on so much, but I'm so passionate about it. It's such an important issue. Thank you very much.
Yeah, no problem. And I agree with you that we need to be active and vigilant, because you've seen that rights are not guaranteed. There can be rollbacks, and there's a lot of, while there's a lot of prosperity in our community, it's so diverse, and there's so much underlying lack of prosperity with so many Pacific Islanders, Southeast Asians, Asian Americans of all types, and we don't realize that, and there's so much advocacy that needs to be done on behalf of our community that that I think. But your comments are really well taken.
So I'm going to jump in. I know there are a lot of students who will be interested in this presentation, and a lot of them are interested in the fact that you're a lawyer. I was curious, how did you decide to become a lawyer? And in particular, how did you decide to pursue education policy?
It's a great question. Williams was such, I want to talk in a Williams context here, because we're a Williams crowd, but there were so many things that I felt like I might want to do from graduating from Williams. That was the beauty of having such a diverse and well-rounded education. I thought at a time that I wanted to be a journalist. I think I wanted to be an international diplomat, because that sounded really sexy, and it would allow me to travel more. I wanted to be a musician, maybe. I was like in the E flats and in the Berkshire Symphony at Williams. So I was like, maybe I want to be a musician growing up. But I ended up going to law school, I think, because first job out of college, I worked for a juvenile justice or juvenile detention facility in New York City, mostly detaining Black and Latino youth who are awaiting criminal trials or juvenile adjudications in family court. And it really opened my eyes to what's going on in this country. I just couldn't believe it. And I worked for a lawyer there, and I think that was a very formative experience. I also juxtaposed the fact that those kids who were detained in New York City, almost all Black and brown, they were so different from my school in Basking Ridge, New Jersey, which was so white. And I was saved by my public education setting in Basking Ridge, because my parents were very busy immigrant doctors. They were never home. And I was literally raised by teachers in the US public school system, who, before school, after school, and all of the opportunities, all of the extracurriculars I got from my public schools. And so when I think about that and how I got to Williams from that, and then contrast that with kids that were Black and Latino, mostly behind bars, not getting it, and they're permanently divorced from education. Their education pathway had been completely disrupted. That was really profound to me. And I think I ended up going to law school and then pursuing education and civil rights as a result of those experiences.
So how did you get interested in AAPI Supreme Court cases?
Well, I think that, it's not an area that I specialize in. I think I gravitated toward them because as I became a civil rights litigator, some of these cases are actually useful. And as I mentioned in the presentation, they're still very foundational. They're used in lots of other cases that don't apply just to Asian American issues or to the specific context in which those cases arose. When they were litigated, they apply to lots of different kinds of cases. So I became familiar with a lot of them, but I think it's really being Asian American. I've always struggled with and wanted to explore Asian American identity. And I think these cases are a way, in law school, it was kind of very eye-opening to read these cases and become more attuned to what it means to be Asian American in the US and what that means and how do I get some privileges from that and how am I perceived and sort of perceived negatively or maybe things that don't happen in a privileged way because of that. And so I think I gravitated toward these cases a lot because of that. I also, as I mentioned, I had a professor, Neil Gotanda, who was Asian American and a critical race scholar. So I refer back to him a lot. But a lot of these cases are critical race CRT cases, critical race theory cases, because they show how race was so how race and the legal system kind of developed together. And CRT is not in vogue these days. Policymakers don't really want to hear about CRT or have it be taught in schools. And there's laws all over the country now that you can't teach CRT. We don't like Nicole Hannah-Jones. We don't like teaching about divisive concepts around race and gender or sexuality. So there's a real movement right now to not talk about these cases, not talk about uncomfortable things because they might be upsetting to kids. And I would argue that the opposite is what we need. We need to lean into the uncomfortable cases and scenarios because they really teach us a lot about America.
You talk about how these are cases that K through 12 students, modified to be age appropriate, should be aware of some of these cases or some of the stories. Do you have thoughts on how to bring that to a greater population? How, is it just in the classroom or are there other sources for this education?
Yeah, absolutely. Yeah, I did write that book. Thanks for holding up my book, by the way. But I wrote that because, it was for K through 12 teachers. And I tried to break down some of the cases, including like the Lau case that we talked about, the maybe one or two others we discussed today. But it really, because there are concepts there and there's a way to describe the stories behind those cases that is very accessible to young kids. And I think that civil rights and civil liberties need to be taught affirmatively to young kids because that's where civic education really comes from. And that's where kids learn about those that are different from them, who are maybe less fortunate. And I think that, what I argue in the book is that kids are being taught about civil rights and equality anyway, even in a passive way, even if they're not being affirmatively taught it in schools. They know what the rules are. They know which teachers favor what students, who's disciplined and who's not disciplined, what clothes they can wear in schools, how they can express themselves or not. So they're learning about civil rights and civil liberties from all of these messages they get in just attending school. So why not complement that passive learning about civil rights and civil liberties? Some of that is negative, like if they're being bullied, and the school's not stopping the bullying because they're Asian, let's say. So some of it's negative passive learning. So why not complement that or even replace that with affirmative learning about what your rights are, what your liberties are in this country, and that'll empower you to be a more active and vocal citizen and participant in democracy.
That makes sense. Sally has her hand up.
Hey, Bob. That was such a great talk. Thank you so much for that. I was taking notes because I teach cultural anthropology, and
Oh,
like sometimes I bring in like there's ethnography about the Chinese in Mississippi, and so like you actually were helping me round out. I'm like, oh, I didn't realize some of the things that you were saying about the case concerning education, right? So one thing I'm kind of curious about, like, because I'm really since I'm not a lawyer and I haven't studied these cases as you have, like, I'm really intrigued by this idea of how the law itself has constructed, like, the what race is, how we not like, so it's not just that there's like ideas about law that or about race that precede laws, but that the laws themselves actually actively construct what we think about what counts as race, right? And one thing that was striking me, because like what I do in my discipline is we talk about things. We talk about discrediting or debunking the science of race in the 19th century. So so a lot of this. So when you were mentioning things about like skin color or claims about Caucasian, like those are these scientific classifications, right? That some of them still tend to get used. So I'm kind of curious to know, like, in when you're in reading these cases and knowing them, like, how does the science of race or the race of science get used in these cases? Like, and do you see like patterns in who gets cited, or like how they get talked about? Like, because it seems to me that there's an interesting intersection of science and law that needs to be addressed, right?
yeah. Well, the cases do use science in talking about how to define race, as a guidepost in a way. But then what it also reveals is that the science is also flawed in a way. How science defined race in previous eras. And so I guess one takeaway is that we think of these things as so sacrosanct, like law, science, and we want to build a system of laws or rules around how people should behave around those things. But what we see is that these are things that need to be critically examined, because sometimes there's an element behind institutions such as courts or laboratories or whatever, however we define science or define science, that ultimately in subsequent generations are proven to be discredited or not so accurate, and based on some assumptions. And so I think that that's really, for me, what critical race theory really was doing that, examining that around law and how it applied to race. And I think, again, people don't know what critical race theory is today, by and large, but they're very against it. But I think when you really study it and look into it, it makes a lot of sense. And some aspect of it, I think, is really valuable when we study the science of the legal system, the science of race as used in the legal system.
So Theodore Cox has his hand raised as well, and then I'm going to read two of the questions that came up in the chat and see if maybe they can all be answered in combination or somehow. One of the questions is, do you think about these cases as purely historic, or is there any way to leverage future advocacy strategizing for more equitable civil rights? And then a separate question from Brandon. Given the current makeup of the Supreme Court and potential second Trump presidency, would you ever foresee birthright citizenship no longer being guaranteed to those born in the United States, particularly to non-citizen parents?
Yeah. Well, the first question, I think, I do think that many of the principles in these cases do have current application. I mean, they still are used, many of them today. I mentioned the Lau case and the rights of English learners. Certainly, some of the immigration principle cases still sort of provide the overall apparatus and framework for immigration cases today. So I do think that these cases are still relevant, but it really, and it kind of goes to the second question too, but I think that the judges that are applying these cases that's as influential as the underlying law itself. And so we know that with a possible change in administration again this fall, that the Supreme Court, we already saw the Supreme Court being radically changed under President Trump to overturn precedents as monumental as Roe versus Wade. I would say that was one of the blockbuster sort of reversals. So I do think that many things, if you consider the current makeup of the court, if we add one or two more justices with similar views as the current majority, then many things, many principles that we think of as sacrosanct may be challenged or overturned. One quick example of that is in my field, separation of church and state. That has been gradually eroded in the public school context. So now public funds and public schools can be intertwined with religion in a way that would have clearly violated the Establishment Clause a generation ago. But we're headed toward a more intertwining of religion and public education in the future, and I really worry about that. And I think we're even with the current court, things may happen in that direction, but certainly with one or more justices that are sort of privileging free exercise of religion over anti-discrimination principles, I think we might be in trouble, moving ahead.
Okay, maybe the last question for tonight, we're going to turn to Theodore.
Yes, hi. Thank you so much for this wonderful presentation. And as an immigration lawyer, it is also my daily fare to see the impacts of these cases on what goes on. My question is really, having met Mr. Korematsu, did he leave you with any impression of the impact of the case on his life and the internment, and how did he look back on that and on the litigation?
I mean, my impression of him, he was so gracious and lovely and upbeat about his life in a way that I never could imagine myself being that way, having gone through what he did. So there was something so admirable about him that, made me feel like, well, I should never complain about anything, because look what he went through. And he still was a proud American and loved this country. So, I mean, that was my sort of big takeaway from him. But, he went through a lot to avoid, during that internment process. I actually saw in some of my notes, researching the case, that he'd actually had plastic surgery to alter his appearance. He'd changed his name to an Anglo name, and he'd had to hide his ethnicity and his race from the government for a time. So there was just so many things that he went through that you could never imagine the government forcing you to do. But my overall takeaway was that he was a special person, and he was a role model.
Thank you.
Thank you so much, Bob. I see we're at time. I really want to thank you for taking the time to share these stories and cases with us. I think it's really helpful for us to better understand the role of Asian Americans and Pacific Islanders in American history. To those who, if you know people who weren't able to attend tonight, we will have a recording of this available in about a week or so. We also have a number of in-person and virtual programs coming up, so please keep your eye on the WAAAN newsletter. And in particular, we're hoping to be able to send out a link so that we can observe the capstone presentations from this year's Asian American Concentration Seniors. So keep an eye out for that. That's supposed to be on May 3rd and May 6th. So thank you again for joining us, and hope to see you soon. Thank you, Bob.
Bye, everyone.